biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state.
The Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Good morning. Please be seated. We're here at the time scheduled for oral argument in file number 2025-034, Sarah Shively versus Kyle Shively. Sitting today, Justice Jared Tufte, Justice John Jensen, Justice Douglas Barr, and welcome Justice Mark Fries. Arguing this morning, we have for the appellant Michael Malloy and for the appellee Kyle Craig. Mr. Malloy, you may proceed when you're ready.
Madam Chief Justice, and may it please the court. Good morning, Your Honors. My name is Michael Malloy, and I represent the appellant Kyle Shively in this matter, who is present here with us today. In Shively 1, this court was clear in its direction to the district court. This court determined that the district court failed to state its findings with sufficient specificity to enable it to understand the factual basis for its decisions. Therefore, the judgment was reversed and remanded for reconsideration and a reasoned explanation of the district court's award of residential responsibility, parenting time, and the distribution of the marital estate. Because the district court failed to follow this court's mandate on remand, Kyle respectfully requests that this court reverse and direct the entry of an equal residential responsibility award and for the entry of his proposed property and debt distribution, both of which are on file with the district court at document number 96 and 93. If this court is uninclined to grant such relief, Kyle requests that this matter be remanded to a different district court judge and that an order be entered consistent with the district court's original findings. Before addressing the substantive issues in this matter, it is prudent to address this court's mandate rule and the effect of the district court's original findings. First, the mandate rule requires a district court to follow the appellate court's pronouncement on legal issues and subsequent proceedings and carry the court's mandate into effect according to its term.
Counsel, I have a question. Are you relying on the mandate rule, or are you relying on some prior authority for the assertion that the district court was required to explain why equal primary residential responsibility was not appropriate? Or both, maybe.
Your Honor, my response to that question is it would be both. In Shively 1, the court addressed the mandate rule, and there was specific direction to clarify and give, not reconsideration, but to clarify the original findings as it relates to the award of equal residential responsibility.
Okay. And did the mandate require was it requiring more findings on the determination of primary residential responsibility, or was it expressly saying you need to explain why not equal primary? And then the second part of that question, which I think you were going to get to, but hadn't yet, is do we have some prior authority that says a district court judge is obligated to explain why equal doesn't apply if it makes a determination on primary residential responsibility?
Your Honor, as it relates to the mandate rule, when this court issued its decision in Shively 1, it was not an opportunity for the district court to re-adjudicate matters or have a do-over. And so in Shively 1, as it relates to the award of equal residential responsibility, this court specifically directed the district court to clarify and reconcile its findings as to why equal residential responsibility was not in the best interest of the children. As was discussed at Shively 1, there is no presumptive rule or statute that says that the court has to grant equal residential responsibility, nor is there any rule that says that the court has to explain why it did not grant equal residential responsibility. But specifically in this case, in Shively 1, one of the remand issues was for the court to give a reasoned explanation as to why it did not grant equal residential responsibility to Kyle Shively and Sarah Shively. As it relates to the district court's original findings in this matter, it's important to note that Ms. Shively did not appeal the original judgment or the original findings. And so to that end, the original findings are presumed to be correct for the purposes of appeal and a subsequent remand. As will be addressed today, instead of following this court's mandate, the district court did make supplemental findings in direct contradiction to the district court's original findings regarding residential responsibility. It awarded no summer parenting time or gave a reasoned explanation as to why no summer parenting time was awarded. And it did not adequately analyze the property distribution under the rough district guidelines to determine whether it was fairly possible to award Kyle the marital home. As relates to the first issue on residential responsibility that we were discussing, this court is aware that the determination of residential responsibility is treated as a finding of fact that will not be set aside on appeal unless the decision is clearly erroneous or the findings are not sufficient to specify the factual basis for the decision. A finding of facts is clearly erroneous if it's induced by an erroneous view of the law, there is no evidence to support it, or though some evidence may support it, on the entire record the court is left with a definite and firm conviction that a mistake has been made. On remand, Your Honors, the court did issue its supplemental findings of fact and order upon remand and order denying briefing schedule. In taking a close examination of the supplemental findings that were issued, I think 3 or 4 months after the court issued its opinion in Shively 1, the court attempted to rationalize its original findings as to the award of residential responsibility and why it did not award equal residential responsibility. In doing so, the district court made additional supplemental findings that completely contradicted the original findings. It took the further step of reversing course and finding that not only did factor D weigh in Ms. Shively's favor, but the court also found that factor E also weighed in Ms. Shively's favor. In the original findings, neither one of those factors, D or E, weighed in either party's favor. In addressing the issue relating to the inconsistent findings and the award of equal residential responsibility, the court on remand addressed a couple of issues. Specifically, the first issue that was addressed was the primary caretaker status. The district court, in its remand on supplemental findings, again addressed the primary caretaker status, but it failed to recognize that in its original findings, it acknowledged that there was no presumptive status as it relates to the primary caretaker, and that there was no indication that Kyle could not step into the roles of a primary caretaker if he was awarded equal residential responsibility. So that is one example of the findings on remand being inconsistent with the original findings.
Also, do you also see inconsistent the district court's findings as it relates to extended visitation during the summer? The district court in its order says the parties don't communicate well, so equal residential responsibility is not appropriate, yet doesn't address extended parenting time during the summer, suggesting that the parties should work it out themselves. Did you see that as inconsistent as well?
Thank you for your question, Justice Freeze. As it relates to the issue on communication, we have to go back to the original findings. In the district court's original findings, it specifically stated that the parties effectively communicated with each other through the Our Family Wizard. The district court found in the original findings that they effectively communicated modifications to the parenting plan, to medical issues, to educational issues. Fast forward to after Shively 1 was decided and the court was on remand, the district court then found that they could not communicate properly, which was in direct contradiction with the decision that it originally made. As it relates to summer parenting time, Your Honor, in my perspective, this was the easiest issue for the district court to decide as it relates to summer parenting time. This court was clear that the award of 7 days to each parent did not amount to extended summer parenting time. And absent a reason for not awarding summer parenting time, this court has been consistent that there has to be extended summer parenting time to make up for the non-custodial's lack of parenting time during the school year. And so the district court I will say its decision on remand regarding summer parenting time was confusing at best. The district court essentially said that Ms. Shively had made an offer of summer parenting time at the trial, which was then not responded to by Mr. Shively at trial. And that, as far as responding to it, before the district court at the original trial, there was 2 proposed parenting plans, one of which was the award of equal residential responsibility that continued the week-on, week-off parenting time schedule throughout the summer. And then a second proposal was made as it relates to Ms. Shively having primary and there being a different summer parenting time schedule on a week-on, week-off basis. The district court essentially disregarded what the Supreme Court has said consistently about summer parenting time and essentially said that because the parties do not communicate well, which is in clear contradiction to the original findings, that once they do start communicating well, they'll be able to figure out their own summer parenting time.
Well, Mr. Malloy, you keep saying that the new findings are inconsistent with the old findings. The first argument was that the first findings were inconsistent. So in order to have one consistent set of findings, doesn't the district court have to choose between some of the inconsistent findings before and they can't be inconsistent before, and then if they pick one or the other or change them,
Your Honor,
become all consistent.
and
Do you see what I'm saying?
Madam Chief Justice, I understand the question, but on remand, under the mandate rule, it does not permit the district court to do a redo and say, I'm going to forget everything that I had thoroughly analyzed and make new findings. And that's exactly what the district court did, is it made new findings completely inconsistent with the original findings. In the original order, we had described the findings as findings A and findings B. In finding A, all of the findings were either equal to the parties or did not weigh in either party's favor. But in the Section B findings of the original findings, the court then said that factor D weighed in favor of Ms. Shively, when previously it said that it weighed in favor of neither party. And so my reading of Shively 1 was for the district court to clarify its findings as to how it reached the conclusion that it did. And instead of clarifying the findings, the district court took the opportunity to make more findings that were completely inconsistent with the original findings.
We asked the district court to reconsider and give a reasoned explanation for the court's decision.
Correct.
So doesn't reconsideration allow to change findings that it thought it was not supported by the record?
Respectfully, Madam Chief Justice, I do not believe that under the mandate rule, the district court is given an opportunity to redo its findings. And this goes back to my primary argument that Ms. Shively did not appeal the original findings, and so those original findings are presumed to be correct. In Shively 1, we acknowledged to this court that we believed that all of the findings were correct, but that the conclusion that was reached by the district court was not consistent with those original findings. And so the court can't the district court on remand can't completely disregard the original findings because under this court's precedents on remand, those findings are presumed correct.
Right. We didn't determine, let's have to find the right word. We didn't determine anything was clearly erroneous in the first set of findings. Is that correct? In Shively 1, we didn't look through the findings and say, these are clearly erroneous. We just said, you got to give us some explanation. We have your findings. Now, give us your logic. Give us your reasoning.
Correct, Your Honor. And that I think this court in Shively 1 essentially said that the court's conclusions based upon the original findings did not match
up. And nobody challenged those original findings.
Correct. None of the original findings were challenged by either party. We argued that they were correct findings. Ms. Shively did not appeal them and say that they were incorrect findings. And so the court is bound by those original findings on remand. But getting back to the summer parenting time issue, this court's been very clear that if the court does not award extended summer parenting time, it has to give a reasoned explanation as to why no summer parenting time was awarded. And the district court did not give a reasoned explanation as it relates to no summer parenting time. I want to transition now as it relates to the award of the marital home to Ms. Shively, that decision was affirmed on remand. In Shively 1, there were multiple questions from Justice Barr, from Justice Crothers, from Justice Tufte, as it relates to whether the district court tied the award of the marital home to its decision to residential responsibility, or if it had tied the decision of the award of the home to residential responsibility. And on remand, the district court made it abundantly clear that it awarded the home based upon its decision on residential responsibility, and it did not make its decision on the award of the marital home based upon a rough Fisher analysis. So what the district court did in this on remand is it gave two explanations. It said that if Mr. Shively was awarded the marital home, it would cause more emotional harm to the children. And number two, it would cause potentially capital gains headaches, I believe is how the district court addressed it. First, just preliminarily, there was nothing in the record that the awarding the home to Mr. Shively would cause emotional harm to the children.
Let me ask you to back up just a half a step first.
Yes, Your Honor.
Are you asking us to announce a clearer rule about the degree to which those two findings can be tied? Or are you mostly arguing about the evidentiary support for the connection that the district court made between those two factors?
Your Honor, as it relates to the rough Fisher
Is it a
guy?
per se problem, an error of law for the district court to say, because I'm giving this parent the home, then I'm weighing that in favor of giving the same parent the children, or in the other order, because I'm giving this parent primary residence responsibility, I also choose to give that parent the home.
Well,
Are those both problems under our law?
The court has already addressed the first issue, that simply because one parent is awarded the marital home does not automatically transition to them being awarded primary residential responsibility.
Doesn't automatically, but can it be a factor? Can it weigh in favor of?
This court has never weighed that in its rough Fisher analysis as relates to the award of residential responsibility. And so if the court affirmed the district court's decision on remand, that would then be a factor that the court would be taking into consideration.
But the rough Fisher guidelines include kind of a catch-all phrase, such other matters as may be material. And can it not be material? Can it not be material to take into consideration the home where the children have been raised their entire lives? On one side or the other?
Your Honor, as it relates to this court's precedents, I'm unaware of any case that did tie that.
But there also aren't any that say you can't.
I do believe, Your Honors, that could be taken into consideration, but it could be potentially just one factor that the court could look at. But the problem in this case is that there was no proposal to the district court by either party that the marital home be sold. So it was either going to be awarded to Ms. Shively or Mr. Shively, and because parenting time is presumed to be in the children's best interest, there would be parenting time in that home regardless of what parent was awarded it. But the district court on remand did not address the sentimental value argument, the source of the property discussion that this court had in Shively 1. It came up with this new theory that the kids would be emotionally harmed, and again, there's no evidence in the record to support that. And then number two, the court indicated that there would be a potential capital gains headache as it relates to the award of the home to Mr. Shively. The district, as it relates to that second issue, the district court already recognized that there would be a capital gains discussion in its original decision because it found that Mr. Shively had to make an equity payment to Ms. Shively, which the only way that equity payment would have been made is through the sale of the agricultural property, which would trigger capital gains. There was very little evidence about capital gains, and the Supreme Court has been very clear that the tax issues of a divorce should be taken into consideration if there was sufficient evidence to the court to find that issue. In the record, there's very, very little discussion about a capital gains issue, and it was actually Mr. Shively that discussed that essentially said there would be capital gains because the property was either inherited or was purchased at a very, very low rate. And so this capital gains headache that the court relies on remand, there was already a capital gains issue that had to be addressed under the original award. But as far as the emotional stability, the district court's decision now is pitting a parent against a child, as opposed to weighing the rough Fisher guidelines to each other, between the parents as to who should be awarded the marital home. The district court erred in not properly analyzing the rough Fisher guidelines on remand as it relates to the award of the marital home, and so we would be requesting that decision be reversed. I see my time is up. I did reserve 10 minutes for rebuttal, and we'll address any additional questions then.
Thank you, Mr. Malloy. Mr. Craig?
Madam Chief Justice, opposing counsel, may it please the court. My name is Kyle Craig. I'm here today on behalf of the appellee, Sarah Shively. We are asking that the court affirm the district court's supplemental findings and order upon remand in all aspects. I'll begin my argument by noting that the appellant's argument largely hinges on the idea that in Shively 1, this court was dictating a certain outcome. In particular, even as I listened to Mr. Malloy's arguments, he began by requesting that the court, this court, direct the district court to order equal residential responsibility and grant his proposed distribution of assets and debt that are already on file. Nowhere in Shively 1 did this court ever opine that that should be the outcome, and indeed this court has the authority.
We didn't opine that it should be the outcome, counsel, but we pretty clearly stated that the court needed to consider whether equal residential responsibility was in the children's best interest and articulate its reasoning sufficiently for appellate review. That's what we mandated, and in the second order on remand, does the court ever explain why equal residential responsibility is not in the children's best interest?
Yes, absolutely. The district court followed this court's instruction to a T. They're specifically on page 3 towards the bottom of the supplemental order. Defendants proposed for equal residential responsibility. District court then goes through a number of paragraphs where it references its prior analysis, comes to the conclusion that ultimately would not be in the children's best interest, consistent with this court's directive in Shively 1. So again, if this court's intent was to order equal residential responsibility, it would have done so. It did so in Law v. Whitted, which I cited in my brief. That was not what happened. Instead, this court said the findings are either inconsistent, as Justice McEvers, you had noted. We need a little bit more explanation as to how that ultimate conclusion came that primary residential responsibility should be with Sarah.
Counsel, did we say the findings were inconsistent, or the conclusion wasn't explained based upon the findings?
I believe in Shively 1, the order from this court was that the determination or the findings were inconsistent or incomplete, and that was the purpose of the remand, and not only issue 1, which is residential responsibility, issue 2, the parenting time, and then also I believe it ties directly into that third issue of the property and debt, which brings us back before this court. But touching on that to a degree, I dispute Mr. Malloy's arguments that the original findings didn't at least give a strong indicator as to where the district court was heading. I draw specifically from paragraph 40 of the district court's original findings, where, and I did argue this when we were at oral argument and through my briefing last time, there is a clear indication as to factor D. I note specifically on the remand issue on the supplemental order, which begins towards the bottom of page 1 and goes in through the bottom of page 3, the district court explains that in a little bit more depth, referencing that even Mr. Shively's own testimony that Sarah was the primary caretaker of the children, had managed all their needs, and additionally, that Mr. Shively voluntarily left the marital home in the spring of 2023. He was not forced to do that. He was not asked to do it. He did it of his own volition, leaving the children squarely under the care of their mother, a factor the court considered heavily. I understand that Mr. Malloy takes issue with some of the further findings or perhaps better explanation as to factor E, where the district court does reference that when the parties were attempting equal residential responsibility for a brief period of time towards the end of 2023, didn't work. It didn't work because they couldn't communicate to that degree. So I take issue with the characterization that the district court is
Mr.
somehow...
Craig, is that a fair assessment toward Mr. Shively that he left the marital home and abandoned the children? What if he was protecting the children from the contentious relationship between the parents? Shouldn't it be laudable rather than punished?
I think that is completely dependent, Your Honor, on the set of facts that are presented for it. The testimony from that the court ultimately found credible, and I note that the district court found Sarah to be credible in that regard, was that he voluntarily left, that he wasn't forced to. Indeed, there are specific findings as to that are supported by the evidence.
Those made in conjunction with findings that the parties weren't getting along, they weren't communicating well, that the children are exposed to some of that.
I'll certainly concede that their marriage wasn't working out, but in terms of when the parties were still living together, that the children were exposed to conflict, there's no evidence to support that. There's no findings to support that. Instead, what the district court found, based on the evidence presented to it, was that there was no meaningful dispute, that up until Mr. Shively left the marital home, and even thereafter, that Sarah was the primary caretaker of the children, that she provided them consistency, continuity, stability, squarely under that factor D that is really the dispositive issue in this case. That factor E, while having some interplay with it, is not nearly as weighty, at least in the district court's opinion, as to factor D. And notably, a court is given discretion, a district court is given discretion as to how to weigh those particular factors. And in this case, the district court very clearly leaned in hard on factor D, finding that the evidence very clearly established that the children had continuity, consistency, stability with their mother, elaborated on that on remand per this court's instruction, and reaffirmed its ultimate conclusion that the children were best suited, their best interests were suited by continuing to reside with their mother as they always have been. And again, if this court wanted to dictate a particular alternative, it had the authority to do so, did not based on what the law mandated. The district court also addressed the issue of equal residential responsibility per this court's direction, and to draw from a comment you'd made earlier, Justice Jensen, there's no requirement under the law that there be an explanation, at least nothing that I'm aware of in this court's case law or anything to that effect. But nevertheless, the district court did follow the district court's instructions, or this court's instructions on remand, found that not only were the children better suited with their mother, but Mr. Shively's plan to care for the children was not in their best interests. He was going to have them at his work. He was going to have coworkers watch them. They were going to be in a livestock barn. There's even a reference to that being potentially dangerous. There's a reasoned thought process that gets us to that ultimate conclusion. The district court clearly followed this court's instructions on remand as it relates to that. Regarding the extended summer parenting time issue, clearly there is law out there, and I'm not disputing that this court has stated that absent a reason to deny it, there should be some form of extended summer parenting time. But as you can see through the reasoned thought process of the district court on remand, there's emphasis on the idea that Mr. Shively sort of did an all-or-nothing approach at trial. Want equal residential responsibility,
Does that justify a court not following the law?
No, Your Honor, and I'll get to my point in a second there, but what I'm emphasizing there is it's not that the court had to choose between a proposal from Mr. Shively, that he be given X number of weeks or something to that effect. He just said, I want equal residential or nothing else. He didn't propose an alternative. But the district court references there is that there's no specification on what he is looking for. And I'll draw back to my original arguments that I presented to this court previously, that this court has never defined what extended summer parenting time is. It's never given a metric. It's never said it has to be. I know practitioners, we generally will look at it and go, well, It should be 6 weeks, or it should be half the summer, it should be something like that. This court has
The
never
court's suggestion on remand was it was something more than the court had ordered, and on remand, the court did nothing different. Is that a fair assessment?
Not quite, Your Honor. I think there's a crucial aspect of distinction there where, as I mentioned towards the beginning of my argument, all these issues appear to be tied into the umbrella issue of whether the district court erred in awarding primary residential to Sarah. So on remand, this court, or district court, I should say, looked at really the two options that it had of sticking with the 7 weeks or a vague, non-specific proposal from Mr. Shively, and it stuck with its original proposal.
7 weeks, 7 days.
7 days. I apologize if I misspoke.
7 weeks
But
might have been.
it is indeed 7 days, and
You make it sound like the court has to accept one person's or the other's. We have a lot of case law saying the court, it's not what you want or what you want. The court has to do what's in the best interest of the children.
correct.
And so the fact that even someone doesn't even propose something doesn't mean the court shouldn't do it.
Right, and I do acknowledge that, and I'll concede that point, Your Honor. But nevertheless, this court has also not established a firm framework for this amount of time must be ordered. And it's our position on appeal, 7 days is sufficient. It is more than what he has during his regular parenting time. And again, that would be the position that we take on that based on the evidence presented in this case.
I think you said, and the district court said the same thing, that there was no proposed parenting plan for the summer from Mr. Shively. But it seems like, if I'm looking at the record correctly, that there was an alternative parenting plan offered into the record on this matter. Are you saying that wasn't accepted into the record for some reason, or?
And I'm drawing from the district court's order, so I apologize if the record
Right. So
disputes that.
Okay, so you don't recall the defendant offering an alternative parenting plan at the record, was Exhibit 201?
And I
it's-
apologize that my recollection of the record isn't sufficient. I'll defer to what the record actually states on that. But again, based on what was presented here, the district court made a determination based on the facts before it. This court has never stated that there must be a certain amount of time, and notably, the district court didn't say 0 parenting time. It just didn't say it to the amount that Mr. Shively would prefer.
Counsel, can you reconcile for me the same question that I asked Mr. Malloy? How does this court reconcile the district court seeing, well, the parties aren't communicating well, but they should communicate and address their extended visitation on their own? They're capable of doing that, and the court won't intervene. How do we reconcile that in light of the remand and the specific instructions that were provided to the district court?
To reconcile that, Your Honor, I would note the district court, almost in every case, encourages the parties to work along, get along with each other. The parenting plan controls when you can't. And that's what I would point the court to, is that if they can't agree to extended time, or they don't believe it's correct, then they fall back to the 1 week. And again, I know that's not what Mr. Shively prefers. It is what the evidence supported and what the district court concluded was in the children's best interest. Which gets me to the final consideration or issue on remand, which was the issue of erroneous distribution of the parties' assets. I'll begin by noting, as I listen to this court's questioning, that I think it is proper, and I submit that it is proper for the court to consider what it did in this case, which in part, not conclusively, mind you, not the only thing that the court considered, but uprooting the minor children from their home. Notably, I believe that is what resulted in this court remanding that issue in the first place, was because if you're going to make a change in determination on residential responsibility, then this is tied hand in hand by that. So I think there is some guidance from this court on that issue that is a factor to consider.
Should we care about the incentives for future litigants? I'm thinking about how you might advise a future client about whether or not to leave the marital home in the pendency of a divorce, and how that might affect their ability to hang on to that home if that's important to them, or how that might affect their weighing of factors and parental responsibility.
Candidly, Your Honor, that advice already is given to clients, even in the absence of a clear hardline rule from this court, that if you abandon the home, that if you surrender it, that if you make it very clear that you're occupying a different residence, it's much more difficult to argue for that. So there already is, in my view at least, as a practitioner, guidance on that particular issue. But as it applies to this particular case, the district court considered a number of factors under the Rough-Fisher guidelines. It considered basically the parties' respective stations in life. For example, Sarah would not be able to do much of anything with the alternative proposal, being given large tracts of undeveloped land that she has no sophistication with, no knowledge of how to operate that, no knowledge of how to sell it at a reasonable price, no nothing. And it contrasted that with the idea that she's been present in that home, taking care of it, the children continue to reside in there, and ultimately found that to be more workable than forcing her out of the home somehow, and this was a proposal that Mr. Shively made at trial, was that she be awarded this rugby home that he had purchased on his own, even though she wanted nothing to do with that. It was post-separation. The court was considering the unique circumstances of these parties, considering the somewhat limited assets and ability to shift them around, and came to the reasoned conclusion that it was most equitable, I should say, in that circumstance to ultimately award the home to Sarah, because there was no other arrangement that would be equitable. There's no other arrangement that would equalize the marital estate in a way that was fair or equitable. So ultimately, the district court further analyzed, and I dispute the claim that the district court did not analyze the emotional aspect of that, because the district court does so at length in the final section of its remand order, which begins on page 5 and comes to the conclusion of it, is he very clearly noted that there was familial ties there that had sentimental value, but there's also reference that Mr. Shively moved out. He left, he got a mortgage, he went and he purchased another home. Specifically, the district court noted that was not necessarily the action of a person who had an overwhelming emotional attachment to that house. That's towards the end of page 5 on the district court supplemental order.
What evidence of emotional attachment to that home was there of the children's emotional attachment to the home?
I can't draw from a specific comment, Your Honor, aside from the idea that children had resided there their entire lives. That obviously would create an emotional attachment, and I think this court can draw that conclusion from that evidence. But that's just one facet of the overall argument, or the overall conclusion that the district court made, was that this is the only property arrangement that works. I don't want to disrupt the minor children because I would have to uproot them and move them somewhere else, to address the appellant's argument that, well, even with parenting time, they would still be able to go there on weekends. That's not quite the same as being uprooted from your primary residence.
Mr. Craig, if the court were to accept the invitation of Mr. Malloy and say that the court erred, should impose equal residential responsibility, would the equities then favor Mr. Shively as it relates to an award of the marital home?
I again dispute that, Your Honor, based on the evidence that was presented here, that he voluntarily up and left that home. That argument was found to be exceptionally weak by the district court, and that was reiterated a number of times, that he did voluntarily up and leave. So to hinge on that emotional attachment, which I think is really the only argument that he's strongly advancing on this, was found to be lacking and not credible pursuant to the evidence that was ultimately presented. So to conclude, the district court followed this court's mandate to a T. This court, if it wanted a certain outcome, would have stated so. It did not. This court directed the district court to make supplemental findings to reconcile the other findings it found to be inconsistent, and the district court followed those directions, ultimately finding that its original determination through that supplemental analysis was the correct outcome, and respectfully, Ms. Shively would ask this court to affirm in all aspects. Thank you.
May it please the court. Your Honors, I first want to touch on the issue of the abandonment of the marital home, and I adamantly disagree with Mr. Craig's assertion that if a party leaves a home as part of divorce proceedings, that they are abandoning that home. There's evidence in the record on this case that the reason why Mr. Kyle Shively moved out of the marital home was to protect the children's well-being. He did not want the children to be subjected to fighting between the parties. He did not want them to be subjected to any further disagreements between the parties. And so if this court adopts a standard that if one party exits the marital home during divorce proceedings, it'll have a very negative rippling effect on district courts. And the reason for that is it is more common than not for one party to exit the marital home when going through divorce proceedings.
But, Mr. Malloy, these are factual issues you're arguing, aren't you? What his intent was, what his emotional ties were, those are all factual issues for the district court to decide in each individual case.
Correct,
And
Your
why
Honor.
they left the home. And so we don't review or second guess those factual issues.
Correct, Your Honor. And I guess the reason I'm pointing this out is the assertion that the district court found that that Mr. Shively abandoned the marital home, and that is not correct. The district court, in fact, commended Mr. Shively on purchasing a property and making a wise financial decision as it relates to abandoning the home. But moreover, to my point that if there's case precedence that says if you leave the home, you're abandoning it, parties will be rushing to the courts to get interim orders. There will be restraining orders that are being filed to restrict access
Doesn't that
to a
already
party's home.
happen?
Your Honor, I think it is happening. To an extent, I think that the courts would be more so flooded with it, because it is so common for parties to physically separate. And in this case, the district court on remand, it talks about how Mr. Shively abandoned the marital home, but in its original findings, he commended Mr. Shively for leaving the marital home to make sure the kids were not subjected to further disagreements between the parties. But as far as the distribution of the marital home, on remand, this court gave very clear direction to determine whether it was fairly possible for Mr. Shively to be awarded the marital home. There was no discussion on remand as it relates to the proposals that were made as it relates to the distribution of the marital estate. As Justice Barr pointed out, there is nothing that ties the district court's hands one way or the other to a plaintiff making a proposal and a defendant making a proposal. The court can adopt one of those proposals or modify it as it deems best. At the district court level, there was a proposal, an alternate proposal that wasn't even addressed by the district court in remand, that Ms. Shively would be awarded real estate that was unencumbered, and that there was other discussion at the district court about her either being awarded the rugby home that Mr. Shively purchased, or that Mr. Shively would sell the property and give the entire equity to Ms. Shively to purchase a new property. That was not discussed at all on remand. The only thing that was discussed as it relates to the home on remand was the alleged emotional harm of the children and the capital gains headache. And getting back to Judge Barr's point here, there was no factual findings about an emotional harm aspect on the children at the trial in this matter. There was very little testimony about capital gains.
You've been talking about what was discussed on remand, and just make sure I'm remembering correctly. There were no oral arguments, no further briefing, no evidentiary. The district court just acted without further input from the parties, right?
No, Your Honor. The district court did order the parties to issue proposed findings to the court. And
Okay.
so in the post-trial, those came in the form of proposed findings and not.
Okay. There was an offer for briefing that the court turned down, right?
I believe there was, Your Honor. It's been a
Okay.
while since I tried the case.
I think he's talking about post-appeal.
Oh,
not-
post-appeal.
On remand, I mean, yes.
On remand, Your Honor.
Thank you.
Mr. Craig, I think there was an extended delay in the decision, and thanks you for clarifying. There was I don't know if it was a formal request for briefing. We had requested additional briefing. The court denied additional briefing on remand and made its decision without taking any additional evidence or briefing on remand.
And we weren't specific as to what proceedings should follow.
No, and I think it left open that question, and I think probably both parties, if I can get into the minds, we were waiting for a decision. I think Mr. Craig finally filed something with the court to see whether the court wanted additional evidence or wanted briefing. The court shortly thereafter issued its supplemental findings without doing either.
The next logical question I have with that, you ask us to remand and assign this to a different district court judge. How could that practically work? If there are inconsistent findings from the original order to this one, and this court is supposed to remand, what would a different judge do?
Your Honor, I
Go over?
believe that the district court on a remand, and this was done in the Law v. Whittick case, 858 Northwest 2D 636. There was a remand in that case to a different district court judge for the failure of the district court judge to follow the original mandate, and there had to be, the Supreme Court ordered that there be a Rule 63 certification. But as far as to what findings that the district court should actually be reviewing on remand, if it's to a different judge, it would be the original findings.
But that's why the case was reversed the first time, because those findings were insufficient to support the conclusions, correct?
The conclusion was contradictory to the original findings. The original findings were very clear as it relates to a multitude of matters relating to residential responsibility in the marital home. The decision was, or the ultimate conclusion was in contradiction to those.
But we said we're unable to understand the factual basis for the district court's award of primary residential responsibility. It wasn't just remanded to explain the conclusions based on those findings. We said the factual basis, we couldn't understand the factual basis. So,
Your Honor, there again, and I keep going back to this mandates rule, that it wasn't an opportunity for the court to do a do-over. The court had to clarify.
what does reconsideration mean? If we ask the district court to reconsider its findings because we don't understand them, why can't the district court change their findings of fact based on more clarification so that we understand what's the reason for its decision?
And I keep going back to this, Madam Chief Justice, is because of the mandate rule. The mandate rule has been very clear that it is not an opportunity to re-adjudicate or to have a redo.
There are three possibilities with the findings, right? On the order on remand, do nothing with them, the prior findings. Issue new findings is one alternative. Issue changes to the prior findings, which is a second alternative, and you can do more than one of these, right? And the third would be to issue new ones that are inconsistent with the old ones without changing the old ones. It seems to me we almost have three separate questions to ask, and that is, does the remand allow new findings? Does the remand allow changing existing findings that were not challenged and not found clearly erroneous? And then the next one is issuing new findings that are inconsistent with existing findings. Would we have to answer all three of those questions?
Does the district court in this case have to answer all three of those?
Well, do
Or
we
does the
have to
Supreme
answer
Court
what
have
the
to
district
answer?
court can do on remand?
Your Honor, some of the cases that I have reviewed, this court's been very clear as to what should happen on remand. The Berdal case comes to mind. I did not cite that in my brief, but in that case, that the court was very clear as to this is what you needed to do, and I think it related to attorney's fees. And so I think that if I could offer one thing to this court is for, on a remand, to give clearer direction to the district court as to what is required to do. The decision in Shively indicated that there needed to be a reasoned explanation for the district court. That reasoned explanation, I believe, has to be based upon the original findings. And so that there is no reasonable explanation as to how we get to the same conclusion based upon those original findings.
Right. Our direction was two-part, right? The first part is we're not able to understand the factual basis for the award. We therefore remand for reconsideration and reasoned explanation of the district court's decision. And isn't it, don't we need to define what that reconsideration includes? Whether it includes new findings, changed findings, new inconsistent findings?
Your Honor, I think that would be prudent for this court to give clearer direction to the district court. I mean, at one point, this court also said that the findings are inconsistent or at the very least incomplete. So we would request relief in our brief. Thank you, Your Honors.
Thank you, Mr. Malloy and Mr. Craig. This case will be taken under advisement, as all cases are, and this court will be adjourned until 10:45 a.m.